How's it going, everybody? Welcome back to Lead Therapy, and I really appreciate you taking your time tuning into my video. For those that don't know, and for those that don't follow my Instagram, which you should, it's Lead1789 Therapy. Last Saturday, YouTube suspended my account for a week. They said that one of my videos violated their terms of service when it comes to posting certain things about firearms. Now, most of you who have followed me for a while know that very rarely have I shown a firearm on this channel. But back in November, I posted a video about a so-called Glock expert saying that a converted Glock could fire 1,100 rounds per second. And most of that video was part of a news story that some local news station did up north somewhere. And in that video, for about 5 seconds, and it was sped up, it showed them taking apart a Glock. And even though I appealed it, they denied my appeal. And I'm not the only one it's happened to. It's happened to a lot of other YouTubers as well. They're even now saying that you can't even insert a magazine into a firearm in a video, or you're going to get a strike on your channel as well. Or anything adding to it. If you buy a new red dot and you show on your video you putting it on, you're going to get a strike as well. But anyway, I'm glad to be back, and I hope you guys continue to support the channel like you did before all this happened. And in this story, we have some good news. An Illinois judge has issued a temporary restraining order on the state's assault weapon and magazine ban. A judge in Effingham County, Illinois, is the first to weigh in on the state's new ban on assault weapons and large-capacity magazines. And it's good news for Second Amendment supporters. Judge Joshua Morrison was asked to grant a temporary restraining order, as the law applies to more than 850 plaintiffs, based primarily on how the law was passed, with plaintiffs arguing that the state legislature violated several laws of their own by rushing to enact the law before the end of the lame duck session earlier this month, in addition to making a case that the law violates the Equal Protection Clause of the state's constitution. Late on Friday afternoon, Morrison issued his ruling and agreed with the plaintiffs and their attorney, Thomas DeVore, or at least decided their arguments are likely to prevail at a trial. And if the law remains enforceable against the hundreds of county residents bringing the lawsuit, even for the time being, Morrison believes that there's a good chance that their rights will be irreparably harmed. Plaintiffs are being immediately and irreparably being harmed each day, in which their fundamental right to bear arms is being denied, and that this harm is continuing in nature. Morrison wrote, elaborating that the new ban not only harms gun owners, but firearm retailers, who may be restricted in their ability to pursue their current profession. The judge believes that DeVore's argument that the state violated its own single subject rule is likely to win on the merits, pointing out that the Protect Illinois Communities Act just doesn't confine itself to firearms and magazines, but also has an item related to drugs in human trafficking. Additionally, Morrison notes that the bill's short description of the bill refers to it dealing with insurance code private adjusters, because that's what the legislation was originally about before lawmakers gutted it and replaced it with its gun and magazine ban language in an attempt to speed it through the lame duck session of the legislature. While DeVore made the process challenge the crux of his argument, he did raise equal protection claims, and Judge Morrison believes the plaintiffs have a strong case there as well. The gun and magazine ban includes a caveat for those who can, in essence, to show good cause to possess them, something that the Effingham County judge says looks a lot like the good cause standard for concealed carry that the Supreme Court rejected in New York State Rifle and Pistol Association versus Bruin. The court cannot find it logical that a warden of a prison included in the exempted persons category is necessarily better trained or more experienced in the handling of weapons than retired military personnel not included in the exempt persons category. It also does not follow that a member of the National Guard would be less trained and experienced in handling a firearm when they are not on active duty compared to when they are. Further, the other rational and logical exemptions have been excluded, such as a person in a wheelchair cannot use a shotgun due to recoil concerns, thus discriminating against a protected class. One big caveat to Morrison's ruling: it does not have the force of law through the entire state, or even all of Effingham County. The new law cannot be enforced against the 860 or so plaintiffs at the moment, but that's it. Still, it's a great start to the avalanche of the litigation headed Illinois' way. While Illinois Attorney General Kwame Raoul will appeal Morrison's decision, the temporary restraining order will remain in effect for the time being, and next week could bring the first hearing, taking on the law in federal court. This is just the beginning of a lengthy legal process, but it's always nice to start with a win. Also help fighting this bill is the anywhere between 75 and 85 sheriffs that are saying that they will not arrest any citizens that are breaking these particular laws. And hopefully there'll be even more to come on board. As always, let me know your thoughts about the story in the comment section down below. And I'm really glad to be back getting out these important stories to you guys about our Second Amendment rights. And if you guys want to help the channel out, please take time to like, share, and subscribe and hit those post notifications. And like I said at the starting of the video, please subscribe to my Instagram, Led1789Therapy. And I hope to see you guys in the next video.